Ooh, oh boy. My boy Gus owns all of Destiny's stupid tax write-off arguments and why they don't work in one vid.
I just got a new guitar. It's like a keyboard and guitar. I didn't really need this. I just really wanted it. But I don't want to pay the tax. The IRS can kiss my... And I don't want to fight them off. So I gotta run.
What happened to this guy? A white woman.
Fight it off. This whole damn video is just a ploy for me to go and buy this stupid and expensive toy. If I put this crazy guitar in a skit, then the stupid IRS just can't do shit. I reported all my income and paid my rents, but believe me when I say this is a work expense.
Casey got served today, breakdowns, says she hasn't got a lawyer, and apologizes to Ethan.
Notifications we got about that.
I'll watch this after, I guess. Plaintiff Jane Doe's reply in support of motion for protective order governing public commentary by trial participants. Oh, they want to do a gag order on me, so I'm not allowed to talk about it. Which is it's fucking retarded, given... I will write it, man. This will be my final manifesto. I will do a full write-up on this entire thing from start to finish, because nobody will cover this unless I write it all up cleanly, just in terms of like all the unhinged, crazy, depraved behavior that the other side has done in the course of this whole case. But comes now Plaintiff Jane Doe by and through undersigned counsel, and hereby submits her reply in support of her motion for protective order governing public commentary by trial participants, and respectfully states as follows. Defendant's opposition to plaintiff's motion grossly mischaracterizes the nature of the relief sought, the applicable legal standards, and the relevant facts. Plaintiff does not seek to muzzle the defendant, nor does she seek to prevent him from defending himself in court. Yeah, no shit, Sherlock fucking Holmes. Rather, plaintiff seeks a narrowly tailored protective order that applies equally to all trial participants. Well, because she's already gotten her bullshit out there, but okay. And is only intended to curb the ongoing harassment, intimidation, and misrepresentation that threatens the integrity of these proceedings and deter witness participation. See proposed protective order, blah, blah, blah. Okay. The record is clear. Multiple potential witnesses have withdrawn their willingness to testify due to fear of retaliation and doxing by defendant and his followers. There's never been any evidence of this submitted, ever, but okay. Defendant has made explicit threats of violence against plaintiff's witnesses. Again, Queeman and Dristigal are not witnesses in this case, so it has nothing to do with that at all, but we can, I guess you could just lie over and over and over and over and over and over and over again in every single motion, I guess, that you file, but okay. Disparaged plaintiff, true. Her witnesses, kind of true. But I mean, like, all of them are actively and continually chatting in Dristigal's Discord server. Like, what do you, like, these are the least secretive people ever. Her witnesses and her attorneys in repugnant terms. Get over yourself. Who the fuck cares? Disclosed the sealed identity of plaintiff. Her name was literally posted on her GiveSendGo when she initially published it. But also her name was used the same day she filed for a protective order. After that, I haven't done it at all, and I've removed it when they've asked, but I like how she keeps saying this over and over again. And published private communications on platforms with hundreds of thousands of viewers. Yeah, this isn't illegal. There's not a law against this, but Defendant claims that plaintiff continues to attack and malign Bonnell online, but provides no evidentiary support, nor can he, for this false contention. Defendant's opposition further asserts that plaintiff's public statements include vitriolic attacks on Bonnell and his attorneys, but again provides no evidentiary support, nor can he, for this false statement. I mean, she tweeted about the denim shit. No? Do they just say that that doesn't count here? But plaintiff requests that these unsupported and false statements by defendant be stricken from the record pursuant to Rule 12F of the Federal Rules of Civil Procedure. Plaintiff also requests that the court admonish defendant's counsel for litigating in bad faith and or impose sanctions pursuant to Rule 11. I see that it looks like they have somebody else writing these now, because this one is formatted quite a bit differently than the other ones. I wonder if they hired somebody else or if one of the other lawyers are writing these now. Are you not allowed to say her username? Pixie? I can say Pixie. I'm just not supposed to use her real name. This is retarded, though. Like, when people do these cases with protective orders because they don't want to be known or they don't want to be associated publicly with the case. Pixie loves the public association. She wants to be publicly associated. She just doesn't want to be quote-unquote doxxed, which is like a child's term that you use online for not wanting people to know your name. But it shouldn't really apply here in a court term. Retroactively, looking back, I wish we would have fought the initial protective order. I don't know if there's a likelihood of success on winning there, but maybe it would just be a waste of money. If I was representing myself, I would have fought the protective order. How are you going to ask for a protective order when you've already publicized all of this online and wrote a Substack and everything else about it? It's an exceptional use of a protective order. And if you look at any of the other cases around this, like nothing is ever done like this. Like this is just fucking wild. Instead, even the evidence submitted by defendant shows that plaintiff's limited public updates, in contrast, have been respectful and have not disclosed confidential information, threatened any party, or deterred any participant. Rather, they seek to encourage participants. How do I even get participants on my side of this? I mean, I don't know what. Why would the person not being protected help you, Destiny? There is a public interest to court proceedings being public. There's a public interest to people's names and reputation. Like if you're filing stuff in public court, you're making a claim. You're basically saying that I think that I've been injured in such a way that I think the state needs to intervene and grant me relief for this particular thing. And all of us have a public interest in having access to the records on that. This is why all the court filings are public. Protective orders and things protecting names should be exceptional, and they are exceptional rather than the rule for these types of things. But defendant's opposition ignores the governing standard, the substantial likelihood of material prejudice test set forth in Gentile v. State Bar of Nevada, which courts in this district routinely apply. The proposed protective order meets this standard and is the least restrictive means of protecting the judicial process. I'm not going to bother reading all the underlying cases. Every time I do, they're horrendously miscited, but I don't know if it is or isn't here. Wait, if they are saying you provide no proof of her speaking out and lying, why not just submit the tweet to the court as evidence or whatever? We probably did in the last motion, but these guys just say whatever. They just lie over and over and over again. And until the judge starts ruling on things, I mean, I think we're supposed to get some rulings on these motions, hopefully within a week, but the big one will be what the magistrate judge recommends in regards to the preliminary injunction. And then hopefully I get approval to go over that transcript publicly. Contrary to defendant's framing, the proposed protective order is not an asymmetric gag order. It explicitly applies to all trial participants, including plaintiff. Didn't she imply that your lawyer was a rape defender on Twitter? Wouldn't that be an example of her attacking your lawyers? Yeah, I don't remember if Andrew included that in a briefing or not, but yeah, I think she did tweet that initially, that Destiny got the lawyer who defended, these guys or whatever. Are your counsel or you planning to respond to these motions? No, there's a name for it when you have a right of reply. Where are my lawyer people at? What's it called? Like a right to reply. Like we've already given our response to their motion, and I think this is their response to our response to the motion or something. Fuck. check. Hold on. We are not entitled to file a SUR reply, SUR-reply. I'm guessing it's like a required response to a thing, so we don't have a right to respond to the response, basically. You should explain why they sealed it. For laymen, it looks like it's the court siding with them because they have reasonable arguments to seal it, rather than it being standard operating procedure. Well, they haven't sealed it yet. It's just sealed until the judge makes a ruling on it. I think generally when you request things to be sealed, they'll be sealed until the judge makes a ruling on it, because if it's open and then they make a ruling to seal it, it kind of defeats the purpose, right? But I'm pretty sure that I think it would be exceptional if they agreed to seal that after it was already in open court and they really didn't have any good legal arguments for it. So it explicitly applies to all trial participants, including plaintiff, and prohibits only that public commentary which disparages, threatens, or intimidates parties, counsel, or witnesses. Disparages? Like what? I can't say. Like, it's so crazy. Discloses sealed identities or confidential attorney communications. You don't need an order for this. It's already not okay to disclose sealed identities or confidential communications. That's why the identities are sealed, and that's why these communications are, if they're confidential. So I don't know why. You would ask for an order about that. Misrepresents legal filings or court orders. How, like, are you allowed to be retarded? If you think I'm incorrect about how I'm representing something, then fine. But I mean, like, I want a protective order against misrepresenting. Like, what does that even mean? Okay, but. Discloses sensitive personal allegations or private details of the parties or witnesses. Like, all of these people are constantly talking about me in Justical Server. Like, I can't say anything about any of these people ever now. And also, it applies to every single person, like potential witness. I don't even know what a potential witness is in this case. Apparently, anybody can be a witness ever. Trump could jump onto this case, I guess. Such restrictions are well within constitutional bounds. Defendant's reliance on this case and this case for his contention that the proposed order violates his First Amendment rights is misplaced. Both cases are inappropriate or inopposite since they involve broad restraints on the press, not on trial participants. The Supreme Court and other courts of appeals have recognized a distinction between participants in the litigation and strangers to it, pursuant to which gag orders on trial participants are evaluated under a less stringent standard than gag orders on the press. Oh, cute. Are they actually trying to read through the cases now and cite them in their motions? Am I inspiring them on stream to do their job? Good job. I'm too lazy to dig through these cases, though, so. Nebraska Press is further distinguishable because the prior restraint was struck down due to the lower court's failure to consider less restrictive means or measures. CB's is also distinguishable because, one, there was no evidence of actual or potential prejudice to the proceedings, and two, it was a white-collar crime case where the courts have found a less significant danger of prejudice compared to cases involving lurid subject matter, which carry a more significant danger of prejudice. In contrast here, one, less restrictive measures would not suffice. And two, plaintiff has presented evidence of actual and potential prejudice. And three, the lurid subject matter of this case carries a high risk of prejudice. 3. Plaintiff has demonstrated substantial likelihood of material prejudice. Defendant contends that plaintiff has not demonstrated a substantial likelihood of prejudice to the proceedings because 1. This case is an early pre-discovery posture, and 2. Plaintiff has only demonstrated speculative harm or generalized discomfort. Both of these arguments fail. First, this case is not in an early pre-discovery posture. Discovery has already commenced. Written discovery requests have already been exchanged by the parties, and responses are due. However, the parties agreed to await the court's ruling on plaintiff's motion for a protective order governing discovery before exchanging responses and documents. I don't know if there's like a formal distinguishing thing between pre-discovery and discovery and whatever. We haven't turned over any discovery yet because we're waiting for the court to rule on some motions, so I don't know, but... Moreover, the case law relied on by defendant in support of the argument is inopposite in Calhoun v. Invention Submission Corp. The defendant requested that sanctions be imposed on plaintiff and her counsel for posting the allegations of the complaint on a website. Discovery had not yet commenced and no trial date is scheduled, let alone on the horizon. Here, in contrast, plaintiff has not moved for sanctions but for a protective order. And 2, the defendant has not just posted the allegations of the complaint, but instead has harassed and vilified plaintiff, witnesses, and her counsel, and threatened bodily harm to witnesses. Okay. And discovery has commenced and a trial date has been set. Nor is Constant v. Cosby helpful to defendant, since the court entered an order imposing limits on attorney speech. Second, defendant's argument that plaintiff has shown only speculative harm is clearly belied by the record. As detailed in plaintiff's motion and supporting declaration, defendant has publicly threatened to kill potential witnesses. I'd kill them if I could. I want someone to kill named witnesses. Again, Jistical and Queeman are not witnesses in this case, but as long as Kiwi Farms continues to post it, I guess they'll continue to copy paste it. I don't know how long you can just lie about something over and over and over and over and over and over and over again. Maybe this will just be the lie that they carry if they get there all the way to trial. Maybe, who knows? Disclosed plaintiff's legal name in violation of the court's anonymity order. Again, this happened before the protective order came out. Since then, not disclosed the person's name. And clearly the plaintiff didn't really care because they withheld that the name was in the video for months so that they could have it in a motion, 6 months into the case, I guess. But okay. Published confidential meet and confer communications. Published confidential. I don't even know if these communications are supposed to be considered confidential, but okay. And engaged in a pattern of disparagement and ridicule directed at plaintiff, her witnesses, and prospective witnesses, and plaintiff's counsel. I mean, plaintiff has done the same to me. I mean, when you've made a public Substack that is unhinged and contains a fuck ton of lies in it, and then you cry that I think that you're a crazy person or whatever, this is just so ridiculous, but whatever. Plaintiff provided specifics regarding Bonnell's vitriolic public commentary and prospective witnesses' reactions to it. Where? I went through all of the declarations, and I think I only saw one person who said something, but it wasn't even... But yeah, I don't know where these filings are. Somebody can link it if it's there somewhere, I guess. See ECF 44, 84.1 and 84.4. I guess we can look. (84.1) and 84.4. Plaintiff provided specifics regarding Bonnell's vitriolic public commentary and prospective witnesses' reaction to it. This is 84.1. I, Jane Doe. Oh, so this is just Pixie. I'm over 18 years of age. I'm guessing. I competent to provide testimony with a personal knowledge. This is so fucking retarded, dude. She's still running with this is just hearsay. I'm sorry, this is double hearsay. One of the individuals whose screen name was blank blank. When was this filed? I don't even remember when this was filed. June 2nd. Oh, right before the hearing. So her evidence of people feeling threatened by me are one of these individuals whose name was censored told me that the defendant sent the video depicting me to their sister just a few months ago. This individual and their sister, as well as other individuals who had initially contacted me, completely deleted their accounts after Destiny posted his video on the YouTube entitled Destiny Addresses Lawsuit. So keep in mind, just to be aware of what this incompetent fucking retard is doing, right, is she's filed a lawsuit against me, and she didn't get statements, declarations, affidavits from any of the accounts that supposedly DM'd her. Like, what the fuck is, how fucking stupid do you have to be? What are you even doing at this point? Why would you not get a single one of these in writing? Why would you not get any names or any statements or verify that any of this information is even fucking true? But then she keeps throwing it over and over and over again in all of her, like, hello? In this video, defendant further violates my privacy by publishing to his almost 1 million followers out of context private messages. The 3 women that provided declarations under seal in support of plaintiff's motion for preliminary injunction expressed fear of being publicly targeted or doxxed. This is hearsay. Make them submit an affidavit or declaration saying it. You can't just speak for everybody. That's not how this works, little bro. You can't just say, like, somebody else said this. You have to, they need to sign that. They need to attest to that under oath. They have to sign a thing saying that I promise this is my sworn and true statement. Because maybe you're misinterpreting things, or maybe they say they wouldn't say that. I don't know why they keep doing this. I know why. It's because it's malicious is the actual answer. But the 3 women that provided declarations under seal in support of plaintiff's motion for preliminary injunction expressed fear of being publicly targeted or doxxed by defendant or his followers, and indicated they were unwilling to participate in discovery or testify unless their identities remained confidential. For this reason, the witness declarations were filed under seal. Like, that's not in any of the declarations. But besides these 3 witnesses, there are 4 additional witnesses I have contact with, but they told me that they are afraid of speaking out or testifying against the defendant because of his likely retaliation and harassment. Attached here, too, as Exhibit A, is a true and correct copy of one of these witnesses named, who has communicated to me her fear of defendant. Desi tried to repeatedly dox one of these witnesses, whose screen name is blank, after he publicly expressed his support for me. That's not a witness. Somebody who expressed support is not a witness. The potential witness will not testify to pertinent information regarding the case unless his information can be protected. Blank has expressed fear of providing any further information. Active defendant publicly called for his death on the defendant's YouTube channel. Wait, have I? Or are they talking about on Willie Mack's YouTube channel? I'm pretty sure that was the thing that Willie Mack published of me. I don't think I ever said any of, I don't remember if I did or not. I don't remember, to be honest, but. The 3 other potential witnesses also believe that the defendant has committed crimes against them by disclosing intimate images of them. The 3 other potential witnesses are your 3 current witnesses. But they are afraid of pursuing legal action because of how he's publicly harassed and insulted me and anyone who has supported me, including my counsel. 3 of these witnesses have expressed to me their fear that their physical well-being could even put at risk if they attempt to pursue justice. Like, how does this even make sense? If you file it under seal, I still get access to the name. You think I'm willing to have these people, like, physically attacked? But if you file it under seal, I won't do that? Like, what? Why am I Destiny in the court filings and not Steven or something? They go back and forth because they're mentally retarded. Almost every individual I've communicated with expressed not only their disgust for defendant's actions, but also their reluctance to speak out publicly due to their concern and fear of defendant retaliating against them. Wow. Wasn't that statement about Justical before they were mentioned as potential witnesses in this case anyway? Yes, yeah. It was like months ago when Willie Mack interviewed me for a fucking YouTube video. Yes. And it wasn't on my channel. It was on Willie Mack's or whatever. Oh, this text message. I'm sorry. I just remember this one. My bad. They did submit this. I just forgot about it because this is the most obviously faked fucking message I've ever seen in my entire fucking life. Stephen Bonnell has abused his position of power and community to gain favor and harass people in the past. I find his actions deplorable and terrifying. I will never feel comfortable being a witness in this case against Stephen unless my identity is protected. I fear for my family, friends, and my current and future careers. Without protection, I am almost certain I will receive harassment and doxing from his community. Nice, based. And it's the first text message they got from this person. Good one. Okay, so those are the 2 things that they submitted for evidence of prospective witnesses being afraid. Gotcha. wait, surely there is some official affidavit from this person that they should have filed instead of this weird written text message screenshot. No, because they don't have any witnesses for this case, because this entire thing is fucking bullshit, and they know it's fucking bullshit, which is why all of this is like either hearsay from Pixie. Oh, it's 1 through 4, not just because this is 81-4 to 81-4-4. I see. It's just I don't have money for a lawyer or anything. Once he knows my name or something, I'm afraid he's going to harass me or get others to do so. And then, like, what? Jistical doesn't even have any info. What the? What is? He doesn't even have any information relevant to this case. What is the claim that I'm sending him video? Like, we're jerk buddies? Like, what? It's so fucking crazy. But okay. My jerkmate duo, yeah. Contrary to defendant's blithe contention that plaintiff failed to tie her alleged harm to any specific statements or conduct attributed to Bonnell, the evidence presented shows that defendant's actions have caused multiple prospective witnesses to refuse participation and has hindered evidence gathering and thus prejudiced these proceedings. When was my first YouTube video response published? What was the date on that? Wait, I thought there was a YouTube video linked in here. Am I crazy? Is the link just not in a different color? Oh. Wait, that's not my... This. Purpose. Destiny addresses his lawsuit. This is February 20th. That text message was on January 22nd. Had I said anything publicly about this yet? How are my statements in the future scaring defendants in the past? Because that text message that they cited here, first of all, this is not relevant to this case at all. He has no discoverable, there's nothing relevant at all. This person said that they were afraid of me on January 22nd. Had I even said anything yet about this? When did Pixie drop her thing on January 20th? Like, they're already afraid? Like, what? Seriously? Okay. Time moves in one direction, don't forget. Oh, she's the one that linked my YouTube video on February 20th. Okay. The evidence presented has shown that defendant's actions have caused multiple prospective witnesses to refuse participation and has hindered evidence gathering and thus prejudiced these proceedings because they have no evidence, so they have to evidence gather after making the public Substack and after filing the lawsuit in the hopes, they're like praying that somebody comes forward with some magical piece of evidence, but okay. This is precisely the kind of conduct that the Gentile standard was designed to address. See also Shepard v. Maxwell. Defendant falsely argues that plaintiff's evidence is vague and unsubstantiated and relied on unnamed and or yet unidentified witnesses. This is true. In fact, plaintiff's declaration and supporting evidence show that she specifically identified 4 potential witnesses that have communicated their reluctance to participate due to their fear of defendant's doxing and vicious attacks. See ECF 85. What is even I'm just curious. I should have unredacted versions of these, right? Is that your fault if they are afraid of you? Don't they need to show actual proof that something that happened they testified? Kind of, yeah, it has to be, it can't be generalized. It has to be like specific and traceable or some bullshit. Okay, wait, what are these? Hold on. Give me a sec, I'm sorry. Dun, 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 dun. Wait, not this. They sent me, what they sent, the versions that they sent me were redacted, so I don't even know personally who these. What the fuck? Seriously? These are, I have the same document. Okay. So there are people who are afraid of me and I don't even know who, okay, based. Absolutely based. Oh, this image is redacted, so I don't know that one. This is redacted, I don't know that one. Oh, and that message is redacted. Cool, all right, cool, that's good. Based. Okay. So I don't know. I have no further information. I wouldn't be able to tell you guys publicly. It'd be nice to know for my own case, so I could like defend myself. But that's cool. That's fine. I don't have to know any of it, I guess. In fact, plaintiff's declaration supporting evidence show that she specifically identified 4 potential witnesses. What does that even mean? That have communicated their reluctance to participate due to their fear of defendants' doxing and vicious attacks. The names of these witnesses were redacted in the declaration, and the evidence submitted in a motion following seal was submitted. Moreover, the 3 witnesses who have agreed to testify and provided declarations would only do so under seal due to their fear of defendants' retaliation. See, but they leaked basically the names for all these people anyway, so a good one. Also, I read all of these declarations. I think only one of them mentioned anything about being afraid or wanting to remain anonymous. The declaration of Brooke, she doesn't say anything about being afraid or wanting to be anonymous. That was the first one that was submitted. The declaration of Abby MC, she says that she doesn't want her real name revealed, yet they leaked and they keep referring to her over and over again as Abby MC, which is fucking stupid. For docket entry 49-4, they're not even a witness to this case. I don't even know what the fuck this person is doing here. None of the witnesses are even relevant to this case. So like, here's an anonymous witness. I am over the age, or I'm above the age of 18 and competent to provide testimony under oath. I have personal knowledge of matters therein, blah, blah, blah. Okay. Beginning on May 25th, 2024, I began exchanging messages with the defendant, Stephen K. Bonnell, on Instagram, subsequently on Discord, where I engaged with him as a fan. Shortly thereafter, beginning late May 2024, our conversations progressed and became more personal. We began exchanging private sexual content with one another, and Destiny shared graphic sexual content of himself alone, as well as graphic content depicting others, himself and other individuals engaging in sexual acts. Destiny shared some of these videos with me directly via Discord messages, but the majority of them were shared through a Google Drive link, which he sent me via Discord for the first time on or about June 2024. The graphic sexual content that he shared with me was mostly digital videos, although some were digital photographs as well. I ceased contact with Destiny on or about November 5th, 2024. I subsequently became aware of the allegations that had been online leaks of Destiny engaging in sexual acts with individuals on or about January 21st, 2025. I became aware of Jane Doe's post on Twitter, where she alleged in part that Destiny shared the videos of them engaging in sexual acts without her consent. Shortly thereafter, I reached out to Jane Doe on Twitter and informed her that I was concerned that Destiny had been sharing private sexual content without consent, stating in part that, quote, back in spring/summer, he had sent me videos of other girls. I assumed that he had consent for these, but I realized he likely didn't. written. Although I had access to the message between Destiny and myself at this point, sometime afterward, I discovered that Destiny deleted the message between him and him in Discord, and subsequently discovered that I no longer had access to the Google Drive containing the graphic sexual content, which would be deleted. This is, like, what is this? This person isn't even claiming that they got anything from me of Pixie, number one. And then number two, they don't even have any context on, like, oh, well, I think these other videos weren't okay. Like, what even is this? It's not even relevant to this case. Let's see, that's one, and then... This is their other quote-unquote witness. On or about April 2022, I reached out to the defense team at Camp on the 2nd via Twitter. Shortly thereafter, we get to arrange together in blank where we began a sexual relationship. Thereafter, Destiny and I remained in contact. I also became friendly with his wife at the time, Melina. At some point, Destiny asked me if I was comfortable with him sharing videos or pictures of sexual content involving himself, as well as himself and his wife. I told him that I did consent to him sharing these videos with me. Thereafter, we began sharing pictures and videos of sexual nature with one another. Most of these Destiny sent for him alone, although at least one of these videos included himself and his wife. On or about mid to late April 2023, Destiny invited me to blank, where he was staying briefly. While at blank, Destiny recorded himself and I engaging in sexual acts. Recordings made with my consent, and I authorized Destiny to share the recordings with his wife exclusively. I did not authorize Destiny to share these recordings with anyone else or to otherwise make them public. Thereafter, I continued to communicate with Destiny online. In late November 2024, I was harassed by multiple individuals while in Discord who informed me that a video of Destiny and myself had leaked online. After confirming this was the case, I confronted Destiny. I don't know if I'm allowed to speak to our... Well, I'm not revealing who this is. So, who told me that he was sorry that any videos involving myself had leaked because of him. Destiny also told me that he only shared this content with a single individual who went by the screen name Rose. I don't believe that's true. Following this conversation, I received messages from multiple women on Discord and Twitter who'd been in contact with Destiny, who told me that Destiny had shared with them sexual content depicting myself as well as others. Sometime after the November 29th leaks, I discovered that Destiny deleted messages between himself and I related to the foregoing. So the ironic thing is, and I can bring this up right now, but I won't because I don't want to reveal what it is. They deleted their messages with me, which is funny because we had talked after this and we're still friends after this. And then I looked at my Discord one day and I noticed, oh shit, they've deleted all of their messages with me. But I also found out that they were hanging out in a certain Justical Discord. But also, regardless of all of that, this also has nothing to do with this case. What? Like, why is this even here? Like, this person has nothing related to the actual complaint filed by Pixie. This person's not making any allegation. Like, there's literally no point for this even being here. They have so much random shit. So the fact that they're trying to say that, oh my God, these witnesses are intimidated, they're not even witnesses. These aren't witnesses to this case. These are like literally, these are like random statements that you've collected from people to just throw on that literally have nothing to do with any of this. Like, I don't even know what I can respond to for these. Like, it's not even the subject matter here, but... Defendant's attempts to ignore or downplay the harm he is causing falls flat in the face of the overwhelming evidence presented. Defendant declared the following about two potential witnesses. Potential witnesses? That's why people like Jessica and Queeman, if I could put their fucking balls in a vice and crush them and then feed it to them and then slice their dick off and kill them. See blank at minute 56:42. When did I even do this interview? I feel like this interview was done in like January or February. Does Willie say? 1, this interview was done a long time ago. 2, this isn't even published on my channel. 3, these people are not parties to this case. These people are not witnesses. They have nothing to do with any of this. And none of my commentary about them here has anything to do with this case. So it's like, it's so fucking stupid. This commentary is not merely uncomfortable or critical, as defendant absurdly claims, but rather violent and extremely prejudicial. This commentary undeniably deters witness cooperation and undermines the fair administration of justice. Both of these people, Queeman and Gisticle, have talked about me incessantly for months after. Clearly, they're not deterred, and clearly they're not afraid. So, like, what are we even talking about here? Like, these people talk about me almost daily. In another of defendant's income-producing streams, I love how they say that, He recently accused the plaintiff and her counsel of fabricating evidence. I love also how we're being honest now. Thank you. We're just taking straight rips from Kiwi Farms. https://uploads.kiwifarms.st data/video/ also their links are broken half the time, so I don't even know. I'm sure the judge will figure it out. Like, actually fucking clown show that they're literally just control F5ing my Kiwi Farms thread every day for their next legal argument. But that's cool to just waste my time and destroy my life and my reputation and everything else over this. That's nice. Thank God my prior circle of friends is respectful enough, though, to not make any commentary about this at all on the other side of it, but only on mine. Very spine-possessing people. Defendant tells his hundreds of thousands of followers, I bet this is a fake message, and clearly opposing counsel and plaintiff are dumb enough to fake this in the stupidest way possible. Oh, is that about the declaration that I'd already read? I think it is a fake message. I don't believe it. I don't believe it. And I'll say it again. Put me in your next filing. Defendant has failed to refute the overwhelming evidence consisting of his vitriolic and threatening public commentary, its impact on witness participation, and its actual and ongoing harm to these proceedings. To allow defendant to continue with his unfettered public commentary will jeopardize the integrity of these proceedings and impair plaintiff's right to present witnesses. Saying all of this while even temporarily sealing the transcript where we spoke in front of a fucking judge is the ultimate in cuckoldry, in spineless weaponization of the legal system, and in weaponizing the white woman status to seal the transcript where we're both under oath and we have to answer honestly in front of a fucking judge. And it's not just the unhinged, deranged and incoherent ramblings of a schizo lunatic that can apply to either plaintiff or her counsel. Like, it's subhuman behavior. Like, the protective order is the least restrictive means. Defendants contends that voir dire, I don't know what that means. Good job.
Voir dire.
Voir dire, a preliminary examination of a witness or a juror by a judge or counsel. Wait, wasn't this a public hearing? How can they make it private? It was public. I don't think they can make it private. Hopefully the judge should rule against that, but we have to wait for the judge to rule on it. Defendant contends that voir dire, that's what he said, right?
Voir dire.
Voir dire. Contends that voir dire, jury instructions or confidentiality orders are sufficient alternatives. They are not. This case is still in the pre-trial phase, and voir dire does nothing to address ongoing harm to witnesses, witness intimidation, and or the risk of future disclosures of confidential material. The proposed order is narrowly drawn, addresses only the harmful conduct already documented, and preserves all rights to file pleadings and argue the case in court. Moreover, although protective orders governing discovery are standard in cases such as the instant one involving sensitive personal information, not only did defendant refuse to cooperate with plaintiff's efforts towards a stipulated confidentiality agreement, but he has actually opposed plaintiff's motion for a protective order governing discovery. And although that protective order would serve to protect confidential, sensitive information of the parties, it would not prevent the defendant from continuing his public doxing and threatening and false commentary. Defendant contends that the proposed protective order would somehow restrict or impact his right to defend himself. The narrowly tailored order does no such thing unless his right to defense involves attacking and threatening plaintiff, witnesses, and counsel. It does not. The First Amendment does not protect speech that interferes with the fair administration of justice. The fair administration of justice, my God. Defendant's attempts to construe plaintiff's motion as nothing more than an attempt to restrict public access to this court is nonsensical. The pleadings are available to the public, and nothing in the proposed order seeks to alter public access. That's literally what a seal does, or unless you're talking about that's what a protective order, if they're filing to protect names and stuff, that's literally what it does, is to keep stuff off the public record. But okay. Say the judge sees through this bullshit. Is it possible for the plaintiff to be forced to do like a full public retraction or something? No, they would never. I would have to like counter seal or something like that, or counter sue or something. But the applicable precedent supports the entry of the narrowly tailored proposed protective order. Defendant fails to distinguish the controlling precedent relied on by plaintiff in her motion. Indeed, the opposition fails to even address or attempt to distinguish the primary case relied on by plaintiff Hernandez, in which the Southern District of Florida imposed restrictions on trial participant speech after finding likely to prejudice and no less restrictive means. Defendant's opposition fails to address the critical distinction between constitution-protected commentary and targeted speech that threatens the integrity of judicial proceedings. Do you get the vibe that Doe's lawyer hates you personally because she's seen all your negative comments? I think they do because it's a personal friend. That's what I'm pretty sure it's a personal family friend. Particularly through the intimidation or silencing of witnesses, restrictions on extrajudicial statements by trial participants are both lawful and necessary. The evidence submitted showing the defendant has publicly threatened, disparaged, and attempted to dox potential, specifically identifiable witnesses demonstrates precisely the kind of conduct these authorities contemplate. The Southern District of Florida recognized in Hernandez, when witness participation is chilled by public attacks, courts may impose narrowly tailored speech restrictions as the least restrictive means of safeguarding the proceedings. This motion does not seek to silence one party or prevent any valid defense. It is about protecting vulnerable witnesses from intimidation and ensuring that testimony may proceed from fear or retaliation. Defendant misleadingly claims that this is a low-profile civil dispute. Opposing thing, page 11. It is not. I wonder what this was in the context of. I mean, it's a civil case. It's not like a huge corporate litigation thing, and it's not a criminal case, but there have been numerous press releases and articles about it, and hundreds of thousands of people tune into defendant's streaming platforms to hear his distorted version of the proceedings and allegations as I just read the court documents, but okay. And to listen to and encourage with financial remuneration his abuse of the plaintiff, her witnesses, and her counsel. They keep bringing this up over and over and over again, despite the fact that I've lost money on this. And they know that too, because that was also part of our hearing, which is probably another reason why they want to keep it sealed. I think this woman could have had law school paid for, but went this route instead. I think she already took the LSAT once, so she probably took it and got like a fucking 70 on it and was like, fuck me. We'll just play lawyer instead. This is not the run-of-the-mill civil dispute, but rather a high-profile dispute with lurid content and a trial participant, the defendant, who has his own streaming platforms with almost 1 million followers. This scenario only exacerbates the high risk of prejudice to these proceedings due to defendants' threatening, harassing, and false commentary. Plaintiff's limited public comments do not warrant denial of the order. Defendant argues that plaintiff's own public statements undermine her request. This is false equivalence. Plaintiff's posts consist of announcements of procedural rulings, for example, sealing of witness identities, a fundraising effort. Defendant should certainly not object to plaintiff's GoFundMe page. It's a Give, Send, Go page. Got him. Since he has been profiting immensely from this case by streaming on a regular basis about it. My lawyer's fees are up to about $200,000 so far. I have not made that much money talking about this case. Not to mention canceled shows, reputational harm that will likely never go away, and everything else involved in this. But that's cute to say this over and over again. They really, really, really like to run with this argument. This profit revenue is evidenced by the number of views on his videos about the case and the number of comments and questions. For example, streamers such as defendant receive revenue from their YouTube channels based on memberships, AdSense revenue. Streamer gets paid based on number of users viewing ads, and super chats. The user pays to have his or her message highlighted in the live chat during a stream. The more money is paid, the more likely the streamer will read the message aloud or respond to the question. A fundraising effort in general calls for information relevant to her case or witnesses. Again, I'm sorry, little bro, but if you want to be a big boy or big girl and you want to be an adult and you want to file a court case, then you should file the case with your affidavits and everything in hand. If you're filing a case with nothing on pure fucking lies and copium, which is what she's done, and she knows that she's done that, and then you're praying to God That after attacking my reputation as hard as you can, after going after everything I have as hard as you can, praying that somebody comes forward to substantiate your bullshit case, that's on you for being a fucking retard. Sorry. CCF 992 to 95. In stark contrast to the defendant, none of plaintiff's posts involve threats, harassment, vilification, saying that I lying about her age over and over again, saying that she was 19, saying that I purposefully wanted my sexual content to be leaked and spread all over the fucking internet. All of that, none of that was vilification? Seriously? Exposure of sealed identity, and again, it wasn't sealed yet, it was the same day, or publication of confidential materials. I don't know what they're even referring to there. Plaintiff has not doxed, intimidated, or mocked any party or witness. There is no evidence that plaintiff's limited posts have deterred witness participation or jeopardized trial fairness, while there is ample evidence that defendant's posts have done so. See above. Further declarations of people that aren't even relevant to this case based. Defendant distorts the request for relief by arguing that the protective order would allow plaintiff to broadcast her message while silencing opposition, but it is patently clear that the request for relief would apply equally to both plaintiff and defendant and seeks only to silence threatening, harassing, and false commentary. See ECF 84.5. I forget. Did their thing allow them for her to keep her stupid fucking GoFundMe up? Her GiveSendGo up? Is it just me, or does this feel like it hinges entirely on the premise that you leaked everything to Kiwi Farms intentionally, despite you being the one most directly? Yes, it does. I think that's one of the overarching narratives that kind of got destroyed at the hearing, which I think is one of the reasons why, another one of the reasons why they wanted that transcript sealed. And it was funny, this is one of the things that I was like happy about, is I could see because the judge kept asking questions where he's like, wait, so he published that to Kiwi Farms? And then she'd be like, well, no, someone else. And he's like, oh, okay. Or when she was talking about, when I found out that she'd sent all of our videos to her ex, and the judge was like, wait, he sent all of your guys' videos to your ex-boyfriend? And then she's like, no, I sent our videos to my ex. I was like, oh. Like he was, like I could see the lights turning on the judge, and he was like, wait, what? Or like, wait, really? But hopefully we can read the transcript soon. Prohibited content. That harasses, threatens, or intimidates some parties, publicizes or repeats any sensitive personal allegations or private details underlying the claims, publicizes or repeats any confidential settlement discussions or communications which are protected under Federal Rules of Procedure 408. You're gonna have, wait, is this even real? Protective order. And part of it is misrepresents or mischaracterizes the content of legal filings. What? Rule 408, compromise offers and negotiations. Prohibited uses. Evidence of the following is not admissible on behalf of either party, of any party, either to prove or disprove the validity or amount of a disputed claim, or to impeach by a prior inconsistent statement or condition, furnishing, promising, or offering, or accepting, promising, or offering a valuable consideration and compromising or attempting to compromise the claim and conduct or a statement made during compromise negotiations about the claim, except when offered in a criminal exception. This is court. Wait, what? I'm sorry, am I not understanding this? This Federal Rule of Civil Procedure sounds like it has to do with whether or not, like, things that you say during negotiations for, like, a settlement are admissible as evidence towards the validity of the claim or whatever. This doesn't sound like it has anything to do with protecting communications. Am I looking up the correct... Federal Rules of Civil Procedure 408. Compromise offers and... Okay, I'll just keep reading. I'm sorry. As a matter of general agreement, evidence of an offer to compromise a claim is not receivable in evidence as an admission of, as the case may be, okay, yeah, this makes sense. So like for instance, if I like, this makes sense. Let's say that I'm like, okay, fuck it. Let's settle. Let's have a discussion, right? We've had discussions on settlement. Oh, I'm leaking more information. Let's say that I was to say, okay, fine, I'm going to settle. I'll give you X dollars, we make a statement or whatever, and then that's fine, right? And you're like, and then they're like, no. And then let's say that like later on in the case, they file. And by the way, I know that he's guilty of this because when we were having discussions of settlement, he offered me X amount of dollars, right? That's what it sounds like Rule 408 is governing. Not like evidence, like you can't submit evidence to prove or disprove the validity or amount of a disputed claim based on the settlement discussions. As with evidence of subsequent remedial measures dealt with in Rule 407, exclusion may be based on two grounds. One, the evidence is irrelevant since the offer may be motivated by a desire for peace rather than from any concession of weakness position. Two, a more consistently impressive ground is promotion of the public policy favoring the compromise and settlement of disputes, while the rules are ordinarily phrased in terms of offers or compromise. I'm sorry. Okay, this is why I don't read reading their citations is painful. I don't know why this was cited here. Sorry, 20 euros. Mandami has said that he wants the city to run supermarkets. Do you agree that it's idiotic? The profit that capitalists make on supermarket products is already low thanks to capitalism, so it will not bring down prices. I mean, yeah, personally, I think it's a dumb thing, but I mean, we'll see what happens. But hold on. Just make sure I'm looking at the correct. Yeah, I am. Okay. Remember that they described this order as incredibly narrowly tailored. So they're saying this is a narrowly tailored order. And the order is, no person covered by this order shall make or cause to be made any public statement, including on live streams, podcasts, social media platforms, blogs, or to the press that disparages, harasses, threatens, or intimidates the parties, witnesses, potential witnesses, or either party's counsel. Oh, okay. What does that even mean? What is a potential witness? Like somebody named in the like pre-trial disclosures? Publicizes or repeats any sensitive personal allegations or private details underlying the claims of this action. What does that even mean? I can't even talk about the subject matter of the court case? Like, publicizes or repeats any confidential settlement discussions or communications which are protected, they're not protected by this, or any meet and confer communications with counsel. What, so I can't bring up the fact that she was, threatening to kill herself if I didn't pay her off? Or that they were asking for $15 million from me initially? Publicly identifies the plaintiff or witnesses whose declarations have been filed under seal, or speculates about the identity of witnesses or potential witnesses, particularly in derogatory, demeaning, or inflammatory terms. So I can't even say if I think somebody's lying. I can't say that like the allegations against me are false. This is not true. What? Misrepresents or mischaracterizes the content of legal filings, discovery, court orders, or the position of any party or attorney. Wait, what the? This is supposed to be narrowly tailored? This is basically a 100% gag order. Like, so I just can't say anything at all about the case anymore. Like, that's basically what this is looking at. To call this narrowly tailored is insane, but okay. Okay, sorry. That was the first meme. And then the second meme is, I think we filed to have the Abby MC shit completely tossed because it was just for, I don't remember. I have to go back and reread. It was a ridiculous submission, but is that their proposal for a gag order? Basically, yes. They call it a protective order, but that's basically what it was. Plaintiff Jane Doe's reply in support of motion to file redacted evidence in support of the declaration of Abby MC and for leave to file under seal. So, first of all, when they filed Abby MC's retarded fucking declaration, they should have attached the evidence to it. I don't know why they didn't. They probably didn't even have it at the time because they don't give a fuck if any of the people talking to them are even making real allegations against me or not, which is evidenced by the fact that they were relying on DMs from people whose identities they hadn't even ascertained before filing the fucking complaint, and then groveling in front of the judge for a temporary restraining order 2 months after filing the case, and then trying to blame their cancer treatments on their late filing. It's just so ridiculous. Don't take the fucking case. If you can't balance chemo and motions at the same time, why are you like, I don't even know if you're competent to practice at that point, but whatever. Defendants attempt to strike the evidence corroborating the declaration of Abby MC reeks of desperation. The evidence corroborating? This is not a corroboration. This is her initial claim that should have been included. It's not corroborating evidence to include a text message. Also, by the way, just to be clear, this is the evidence that she submitted to that she gave to the attorneys. By the way, Destiny sends me sex tapes all the time, and he thinks, I don't know, the girl's in them, but I have videos of him fucking Cherry and Pixie, like Limfeo. He just sent me another one. Haven't opened it. Let's see who he's fucking this time. He should be more careful, basically. Limeo. This is the totality of the evidence that this person has, that I've ever sent them anything, which I haven't. Because another thing they admitted in the hearing, that they said very clearly, I think on 2 different occasions, was this person never gave them any evidence whatsoever that I actually sent her anything. There was no evidence of that ever submitted, ever. They admitted that they hadn't seen evidence of it at all. And I also know this is the person who I showed was apparently taking pictures of my fucking computer when they were at my house. So I don't even know what they've seen or haven't seen on my computer, or what, because like this video doesn't even exist. This isn't even a real thing. This is not even a real thing. Also, I like how they also edited part of a redacted fucking filing too. What, you couldn't redact the person's message? But this is the totality of evidence that this person has. It's like this, in case you're not aware, this is the one thing right here. This is the entire case is built on this one message. The entire motion for summary judgment that we're filing, right, on whether or not the case will get tossed or whether we have to actually go to trial, all of it will come down to whether or not the judge thinks that this is a factual dispute that would need to be settled in a jury trial. It will all come down to this one singular message. I don't know how judges ordinarily rule on evidence stuff like this, but y'all should depose Abby MC, you mean? Because I don't know who the other person is. Yeah, maybe if it gets that far, maybe we'll do a deposition. Hold on 1 second. Does the judge differentiate between loaded words and their actual meanings? Like when you say corroborating? Oh, I don't know. I'm just saying that like they're acting like they're submitting more and more evidence that's corroborating this person's statements, but it's not corroborating evidence. This is just the text message that they referred to in their first declaration. It should have been submitted with her declaration, but I don't know why they didn't. I thought you tried to serve them and they couldn't be found. Yeah, we're trying, but. That text doesn't even prove you sent the Pixie one before October 2022. You mean after? Yeah, no, it doesn't prove anything. And like I said, I've gone through my messages with this person, and I haven't done. It's just not true. The person is lying. It seems like there's just an endless back and forth of filings between plaintiff and defendant. When is there going to be any rulings by the judge? Well, these motions should be ruled on soon, and then hopefully we get something from the magistrate judge soon relating to the preliminary injunction. But like judges are busy; they're not going to be like proofreading every single motion or going through all this bullshit. Yeah. Do they need proof of this part of the trial? Well, I mean, you could argue that their proof is her testimony, right? The proof would be her saying, he sent me those videos. And so, I mean, if it was a very conservative judge, again, I don't know what the standards are, like the strict standards are for summary judgment. Like an incredibly conservative judge, I guess, could theoretically rule and say, well, this is a material fact dispute, and it's not up for the judge to make a ruling on that. So then the entire trial would basically be putting Abby on the stand and then having her testify. But she must agree to be deposed and answer any questions before MSJ. Oh, motion for summary. Oh, maybe that's true. Maybe if she refuses to be deposed, then maybe it gets tossed, I guess. What would be the reason for you to not show publicly all the DMs with this person? Because technically, why not? Wait, was there a reason for this? Oh, I don't know if it would count as like revealing the person or whatever. So I don't even know if I would need to. Also, I'm not dumping my whole DM history. It's fucking gross. But I mean, like I said, like I went through and I looked at the particular date and I know which two videos I was talking about. Both of them refer to, I know exactly which two videos were, and it was nothing to do with this complaint or any other people involved in this complaint. It's nothing related to that. Like I know exactly what they were when I was referring to on that date. And this person probably should know as well. Like you can even tell by reading their responses to me that they know what it was. So this is just it's a total fucking lie. But I think that this person is, I could say a bunch about them, but they have their own set of problems. But anyway. Defendant's attempt to strike the evidence corroborating the declaration of IBMC reeks of desperation. See defendant's opposition plan. For months, the defendant has been gloating on his platforms to his hundreds of thousands of followers that despite his heinous acts, he will not be held accountable because he allegedly shared the video prior to the effective date of Cardi. No, I have not said that I think anything wrong happened or that anything was done, non-consensually, whatever. That would be an argument that we could have if they had subject matter jurisdiction. But the first argument we're going with is, of course, is you're trying a case that you don't even have the authority to file in federal court. You chose to file in federal court, and you chose to file under the statute, and you chose to deliberately lie in the filings, one, claiming that you had evidence from people that didn't exist or that you hadn't gathered evidence from, and two, by lying and misstating the date of a submitted text message in order to bring it in range so you could file this in public court, in federal court, so that you could have your fun day parading around on the internet like you meant something. So that's on you. Sorry. Indeed, to date, defendant's entire defense has hung its hat on this alleged lack of subject matter jurisdiction. That's wrong, and that's a lie. But I can't read the court transcript where we talked about this in front of the judge, so I guess you got me there for now. But despite defendant's harassing and threatening commentary intended to prevent witnesses from coming forward on plaintiff's behalf, a brave witness did come forward and provided a declaration evidencing that defendant shared the video with her after the effective date of Cardi, thereby defeating defendant's only defense. Okay, that's not my only defense, but even without the IBMC testimony and evidence, however, there are strong legal grounds for finding subject matter jurisdiction under, inter alia, the ongoing distribution doctrine. So there's another Kiwi Farms argument where they're saying, well, if you send a link to a thing, technically you're always continually and forever sending it. But again, my counter argument there is that means that every single thing you ever send ever is always being continually forever sent. That would be true of every single digital platform ever, which is fucking stupid. I've never seen a court case ever that uses this standard to determine ongoing distribution, but they're welcome to cite one if they can find it. Although actually, I think in the hearing, I think they admitted that they had zero case law to back that claim up as well. Defendant's opposition relies on false and misleading statements, a mischaracterization of the evidence, and inapplicable case law in its futile attempt to strike the corroborating evidence. The very premise of the opposition is false. The evidentiary hearing on plaintiff's motion already occurred. Now, on the eve of the court issuing a ruling on her motion, plaintiff seeks to submit new and untimely evidence in support of her motion, depriving Bonnell of an opportunity to respond or to challenge the declarant in open court. The actual facts are that 1. Abby MC's declaration was submitted on May 2nd, 2025 in support of plaintiff's reply to opposition to motion for a preliminary injunction. Yeah, but not her actual text message. How are you allowed to talk about stuff in the hearing when it is sealed? I mean, it's just the transcript that's sealed. I should be able to talk about the hearing. I mean, I was there and it was public. It was a public hearing. The only thing that's sealed is the transcript. 2, the declaration specifically referenced and quoted a text chat thread in which Abby MC told her friend that she had just received a sexually explicit video of plaintiff from Bonnell. 49-2. I don't even remember what her original thing looked like. Wait, does it quote anything here? I told my friend that Destiny sent me another video of him and another woman that I recognized as the streamer with the screen name Cherry. That's not even what she said. It doesn't even match that doesn't even match what the additional stuff that she filed. She said that I told my friend that Destiny sent me another video of him and another woman that just another person. So she doesn't even accurately summarize. I'm not going to say anything. Or whatever. Maybe like her affidavit here doesn't even match the text messages that she submitted. But okay. The declaration specifically referenced and quoted a text chat thread. I don't see any quotations here or quote marks, unless I'm missing something. But okay. Maybe quoted means something different to them. The evidence is not new, but rather is evidence corroborating Abby MC's declaration in the form of a screenshot of the referenced and precisely quoted text chat thread. The evidence was submitted before the June 3rd preliminary injunction. I like how they don't put the date that they submitted this evidence, but they do put the date they submitted her original declaration. The June 3rd preliminary injunction hearing, by the way, the evidence that they submitted of her corroborating text message was on June 2nd, by the way. But okay, good one. Wait, fuck. What is the... Wait, it was this? Sorry. It was this. Sorry, it's annoying because like, it seems like I'm being a stickler here, but this is the only piece of evidence that is keeping this case alive. They know it. This is why they are desperately trying to salvage what they know this is a lie, but they're desperately trying to salvage this. And it's just irritating that they're not even summarizing their own evidence correctly, right? So they say that the declaration specifically referenced and quoted a text chat thread in which Abby MC told her friend that she had just received a sexually explicit video of plaintiff... Wait. Wait, did I just misread this? It's okay. The declaration specifically referenced a quoted text chat thread in which Abby told her friend that she just received a sexually explicit video of plaintiff. Oh wait, no, even this is not correct. Wait, I don't even know what the fuck I'm reading anymore. I'm sorry, hold on. The declaration specifically referenced and quoted a text chat thread in which Abby told her friend that she had just received a sexually explicit video of plaintiff from Bonnell. So that's not true. She says, by the way, Destiny sends me sex tapes all the time, and he thinks I don't know the girls in them, but I have videos of him fucking Cherry and Pixie, like Limfeo. He just sent me another one, haven't opened it. Let's see who he's fucking this time. So this text that they're summarizing here doesn't even accurately summarize this, number one. And then number 2, her declaration doesn't even match her own text thread here, because she says, on or about November 3rd, I messaged a friend of mine and told him that Destiny had sent me the above-mentioned sexually explicit video of himself and another woman, and that I had recognized the woman as the streamer Pixie. I also told my friend that Destiny had sent me another video of him and another woman that I recognized as the streamer with the screen name Cherry. I was able to recognize Cherry just by her voice, and since the video was a black screen with audio of their sexual interactions, I retained in my possession a copy of them. But that's not even really what she said here. She said that I had sent her tapes of Cherry and Pixie, and that I sent her something different this time. So her own declaration doesn't really match the submitted text message here, the 2 messages that we see with no other context around it or anything else. I have no idea who these are to or what this is in reference to. And then their summary doesn't match their newly submitted evidence, nor does it even match her declaration. Okay, sorry. Anyway, it's just fucking retarded, but whatever. The evidence is not new, but rather is evidence corroborating Abby MC's declaration in the form of a screenshot, blah, blah, blah. The evidence was submitted before the June 3rd preliminary injunction hearing. And 2 and 5, Bonnell could have subpoenaed Abby to testify at the hearing, but he did not, thereby waiving any objection to her declaration. I think we've tried to subpoena her, but we can't get a hold of her. Like, they're not accepting service on her behalf, and we can't find her anywhere right now. So, okay. The evidence at issue is not new and was timely submitted. Defendant mischaracterizes the corroborating evidence submitted as new and untimely. In reality, the text message plaintiff seeks to submit was explicitly referenced in paragraph 7 of the declaration, but it wasn't explicitly referenced. There are no quotes. There is no quotation mark here for anything. This is at best, it's a summary of this message. It doesn't even match the content one-to-one of the message. And again, we're in a court case, so it's kind of important that you're being specific with your words. So, whatever. Which was filed on May 3rd, 2025, well before the evidentiary hearing held on June 3rd. The evidence is therefore not a belated submission, but rather documentation corroborating a declaration already in the record. Courts routinely allow such corroborative exhibits, especially where they support previously submitted declarations and relate directly to evidentiary matters under review. Unlike in Butler v. Garland, plaintiff is not attempting to reopen the evidentiary record or offer post-hearing supplemental declarations. Instead, plaintiff merely filed corroborate. They keep calling it corroborating but whatever. Material that reinforces previously submitted evidence already before the court, all filed prior to the hearing, the day before the hearing. Defendant's reliance on Butler's misplaced since it has no relevance here, where Abby MC's declarations and corroborating evidence were submitted prior to the hearing. Ironically, on May 30th, defendant objected to Abby MC's assertion in her declaration the defendant sent her the video because she provided no support for this baseless contention and failed to attach any exhibits reflecting the alleged transmission of the video. In response, plaintiff submitted the corroborating evidence of her text message. Why wasn't that included with the original filing, number 1? And number 2, there's still nothing that has to do with transmitting any videos to her. But defendant further argues that because plaintiff had notice of a jurisdictional challenge, the evidence had to have been presented at the hearing or else risk waiving the right to present such evidence. This, of course, is nonsensical because the court never said it would only consider evidence presented at the hearing. The briefs and supporting evidence submitted prior to the hearing are also part of the preliminary injunction record. Also, neither of the cases relied on defendant's contentions that the evidence is new and untimely. Defendant's evidentiary objections like merit. Defendant argues that the corroborating text message is inadmissible hearsay and unauthenticated. However, such evidentiary objections are premature and misapplied in this context. The court may consider hearsay in preliminary injunction proceedings, particularly when it supports testimony already presented via declaration. Preliminary injunctions are customarily granted on the basis of procedures that are less formal in evidence, that is less complete than in a trial on the merits. All well-pleaded allegations in the moving party's complaint and uncontroverted affidavits filed in support of the preliminary injunction motion are taken as true. Uncontroverted, meaning we don't contest them, no? Isn't that what uncontroverted means here? Furthermore, in reviewing a preliminary injunction motion, a district court may rely on affidavits and hearsay materials, which would not be admissible evidence for a permanent injunction, if the evidence is appropriate given the character and objectives of the injunctive proceeding. Did the magistrate judge say anything in the hearing about the fact that Jane Doe submitted these exhibits on the day before the hearing? No, we brought it up a couple of times, but they kind of stayed away from the, they didn't really touch much on the Abby MC stuff. It's just, you know. Furthermore, in reviewing a preliminary injunction motion, a district court may rely on... The exhibit is consistent with Abby MC's declaration and includes metadata and contextual cues sufficient to support its probative value. The text message dated November 3rd, 2023 directly corroborates paragraph 7 of the declaration. The defendant transmitted a sexually explicit video of plaintiff to her. How does that... the date corroborates that I sent them a video? In what world does every... Okay. Defendant's claim that this message lacks probative value is contradicted by his own recognition that it supports plaintiff's jurisdictional arguments under the Carty statute. Defendant has failed to present any valid reason for the court to disregard or strike the declaration or the corroborating evidence that ABMC's declaration and the corroborating text message are properly before the court for purposes of the preliminary injunction determination. ABMC's non-testimony at hearing does not warrant exclusion. Once again, defendant is litigating in bad faith by deliberately distorting the facts. Defendant asserts that Abby failed to appear to testify at the hearing and that ABMC refused to appear or testify at the preliminary injunction hearing, but defendant knows that neither he nor plaintiff requested ABMC to testify, and there is no evidence to support his spurious assertion that ABMC refused or failed to appear. Defendant also deliberately attempts to mislead the court by stating, plaintiff's counsel refused to accept service of a subpoena on her behalf. ABMC has thus far avoided personal service. Defendant did not provide any evidence in support of these spurious assertions, nor can he. This is because the referenced request was on May 15th, 2025 for a subpoena to produce documents, not for ABMC to testify at the hearing. Moreover, plaintiff's counsel never refused to accept service. Instead, less than 24 hours later and before counsel could respond, defendant's counsel said he would proceed to serve ABMC himself. What? And then they didn't respond to it? Defendant has not provided any evidence of attempts to serve ABMC, and there's certainly no evidence she's avoiding service. How do you have evidence that somebody's avoiding service? How do you even do that? I don't think I can't publish emails or whatever, but okay. Records of dates and times you attempted to serve. Oh, maybe if they use a service provider, which they might have. Maybe that'll show up in another filing, I guess. Plaintiff has no obligation to call every declarant as a witness for the hearing, and the record is clear that defendant did not seek to call ABMC either. Defendant chose not to subpoena or depose ABMC in advance, despite having notice of her identity and the substance of her declaration a full month prior to the hearing. The court's order scheduling the hearing did not state that all witnesses needed to testify in person or that the declarations and other evidence submitted would not be considered. That is true. She didn't need to be there. That is true. But you would imagine that you would want your solo witness that is holding your subject matter jurisdiction to be there. You would imagine that, but who knows? Who cares? Courts do not require personal testimony from every declarant, where their written declaration and supporting evidence have been timely submitted. Technically, I don't even know if either of us needed to be there. I think technically we both could have skipped it, but I don't know if anybody's required to be at that hearing. I'm not sure. I'm not 100% sure on that. Although affidavits are ordinarily inadmissible at trial, they are fully admissible in preliminary injunction proceedings. Defendant's argument that he was denied the opportunity to cross-examine ABMC is baseless. Defendant had over a month's notice of ABMC's declaration and its contents, but failed to issue a subpoena, notice a deposition, or otherwise secure her attendance at the hearing. The corroborating evidence of the text message presented nothing not already in the declaration, and thus does not change the fact that defendant had a month's notice. Plaintiff was under no obligation to call every declarant, and defendant's strategic choice not to compel ABMC's testimony constitutes a waiver of any objection to the court's consideration of her declaration or the corroborating text message. Defendant did not object contemporaneously, nor did he move to strike the declaration. His silence and inaction constitutes waiver. A party cannot remain passive and then claim unfairness when the record closes. As a final matter, plaintiff notes that the defendant had not objected to that portion of the motion requesting that the unredacted version of the exhibit be filed under seal. The exhibit plaintiff seeks to submit is not new evidence, but it's merely corroborative declaration. Okay. Jesus Christ. You kind of skipped the last part. What does that mean? What does what mean? What last part? The last part was just a conclusion or summary of... Fuck. Why is all this shit so slow to have anything happen? It's court. It takes a while. This is just a summary of everything that was said. Did you reach to subpoena her? Yeah, we've been trying to, but... Initially, they said that they were representing her to sue me, and then nothing came of that. And I think we requested to do something through her lawyer, but then they said that they don't represent her, so they can't accept. Or I don't know if they said specifically they don't represent her. They said that they can't accept service on her behalf. And then apparently, been trying to serve her, but we can't find anywhere to serve her for documents. So. Destiny, chances of it getting unsealed. It should be unsealed. It should be. We just have to wait for the judge to rule on it. My understanding is there's like no basis and no world where that actually happens, where the judge would allow a public hearing to retroactively be sealed like that. We have to fight for every hearing to be public? I don't know. Who knows? Hold on. Oh, okay. If it's sealed, does that mean you can't even talk about it from your own memory? Yeah, I can talk. I'm pretty sure I can talk about it from my memory of what have happened. But I wanted to, it would just be nice to read the actual transcript. Do you have to wait until December for summary judgment? I think you can file summary judgment anytime you want in the discovery phase, but it's best to wait for most of the stuff to be in, so. Okay. What are the chances that anyone who talked on the situation takes down their video or at least addresses the new changes later on down the line? It's probably super unlikely. Who knows? I don't even know how it'll... Because I think because some people are trying... The narrative is shifted over and over and over again based on how a retarded plaintiff looks. And now that they look super retarded, like every 10 IQ point drops, there's like a new narrative. And right now, the narrative is just that if I win, it's on a technicality, or some people are, even a lot of you guys are doing, they're like, oh, well, they both did something really wrong. And it's like, no, or we just had an understanding that plaintiff is misrepresenting because she's basically ass paying that she got outed as fucking streamers. But who knows? We'll see. What is this?
Dad and Expo have a beef that we've been doing for a year.
Anissa,
great.
iDubbbz, Anissa, you care about your influencer boxers. You care about them so much. Give this guy 10 grand. Give this guy 10 grand.
No,
that's what I got
Give
paid.
Him $10,000.
That's what I got paid.
No, I'm serious.
No,
serious.
well, I'm gonna get
help
money
you
for
out.
training.
I could help you out. Ethan could help you out. There's a million people that can help you out, right, Dad? But the person that owes you money for all your time and all your troubles is literally Anissa and iDubbbz. Give him 10 grand. Give him $10,000. He's been training for a year. He's went viral on Creator Clash 1, Creator Clash 2. This guy has taken so much shit just because of your mistakes, because he's the poster boy. He's the guy that goes viral, right? He's the guy that helped build Creator Clash. And now he's over here suffering? Well, this is bullshit. Give him $10,000. I demand $10,000 for Nathan Barnett, a.k.a. Dadbot. I demand it. Yeah. I absolutely demand it. It's ridiculous.
I don't want money that it's not. I don't want people just to give me money.
It's ridiculous.
Everyone did the same thing. I trained, I fought, I did my fight, I did promotion. I happened to go viral. It's not. I can't control
it's
that.
insane. We just need to make this content cop so bad, even though it's going to completely fuck you over. And then they're going to preach that they care so much about these influencers. You know what shit I got when they're telling people I don't care about Wings or Boogie? Motherfucker, I gave them 10 grand.
It is kind of crazy that this is like an Elon Musk tier situation where if you have stock in this company and you care about Tesla or SpaceX or whatever, and then and Elon is out here making crazy political statements, I imagine you would feel incredibly ass pained that he's fucking ruining your portfolio. Much the same. I would stay in New York. If you're like at Creator Clash and you're one of the fighters here and you've been giving up a lot of training for this or whatever, and then the lead organizer and face of Creator Clash goes out and starts making insane political statements, I just don't know how I would be so ass pained. Like, what the fuck is wrong with you?
I would stay in New York City. My plans are to address New Yorkers across the 5 boroughs and focus on that.
Wait, what?
I would stay in New York City. My plans are to address New Yorkers across the 5 boroughs and focus on that.
You got my vote. There it is. It's that simple. I don't agree with the socialist policies. I don't like the fact that he's like not speaking.
Yeah, of course he's going to be aligned in this way. Meanwhile, Anissa donated $1,000 to Kaceytron. Wait, really? We don't know this 100%, right? It could be somebody who's donating under her name. That would be a big troll, though, if true.
And then and I said earlier they used my dad's disability to trick him, but that was unrelated. It was just today we've been like calling on my dad's disability, you know, because I've been like working towards trying to get my dad on disability, and we were like responding to some calls and notifications we got about that. And then like a few minutes later, the next thing I know, my dad comes in and he's like fucking crying. You know, it's really fucking traumatic to see your dad cry like that.
I started you all off with my own donation, so you all know how important it is to me. Thanks in advance, love you all, and I appreciate all the happy birthday wishes. Oh, she did donate. What a disgusting fuck loser. Lives with her parents on fucking disability while smoking how much fucking weed? And then is crying as she gets served with a lawsuit.
You know, like that's what really like has me like so freaked out, is seeing like how emotional my dad got about it. You know, like, and I know people are gonna be fucking making fun of me for this, and like they're gonna be posting like videos of me like crying and laughing at it and whatnot, you know, like I don't know, like I'm sure like what you guys are watching right now, like every fucking incel community that's been attacking me relentlessly for like the past 10 years is going to use it for YouTube clips, because they literally make careers out of bullying women like me. And I'm just so fucking tired. I'm just so fucking tired of constantly being harassed by this shit, you know, like.
You love it though. She loves it. This is why the people that post on Kiwi forums and Snark forums are anonymous. Most people aren't stupid enough to throw their name behind the unhinged and subhuman, degenerate shit that you guys are constantly slinging at everybody. You deserve every horrible outcome of this court case or whatever. Like you earned this so much. You're here gloating and happily, you know, goading people on and, you know, bouncing around with glee and talking about people's kids and making unhinged accusations against people online and saying unhinged crazy shit on your public Twitter all the time, constantly. Like, Jesus.
for the past 3 or 4 months, I've really just been like, I just want to focus on myself and I want to focus on my community. I want to focus on being funny. I want to be one of those people who's just a breath of fresh air, you know, somebody who people can watch to escape and get away from it all. I just want to be focused on being funny and being giving and focus on, you know, the gays and the girls and the people who uplift me so much. You know, like we just got done doing our Trans Lifeline fundraiser and shit, and it just made me so happy. You know, like I said, it's just been such a fucking struggle, and I'm just so fucking tired of struggling, and just the idea of having to, like, keep on struggling and it just be an ongoing thing for, like, the next several years of my life. It's just like, I don't know if I can fucking do this. You know, I'm just so fucking tired, and I'm so fucking tired of just, like, you know, like, it's like you don't get a lot of support whenever you're attacked by these hateful incel communities. I mean, like, even outside of the shit that Ethan is doing to me, it's like, it just makes every fucking incel community that has hated me for years attack me once again. And it's like, I felt like I was finally getting away from that kind of harassment. You know what I mean? And it's just like evoked like all of that all fucking over again. Like I'm being attacked by like fucking incel YouTubers that make content for incel men to make fun and laugh at women.
Somebody said this is how Kaceytron reacted to Asmongold's mother's death.
Yes, I did like that tweet. It says, thankfully, XQC's lifestyle hasn't led directly to the death of one of his parents yet, so he has that going for him over Asmon at least. I'll admit, I did like that tweet, and I have a lack of respect for Asmongold after letting his mom with COPD live in those sort of conditions. I'm sorry. Like, you're a millionaire. You have all of the resources in the world. Why is your sick mother living like that? Like, I'll say it. I don't care. If that makes me a bad person, I'm still miles above of Asmongold. Miles above Asmongold.
I wonder what her dad is on disability for. I wonder if that's impacted at all by the insanely dense bong clouds that are constantly gathering around Kaceytron's room.
Sorry. Like, I have literally a fraction of the income, and I take better care of my parents than that. And I don't have anywhere near close the resources that he... Going through traumatic things. You know, like I'm being attacked by like fucking the quartering incel channels that I've never even fucking heard of. The fucking rape reviewer, Nicholas DeOrio or what the fuck ever. You know, Asmongold's community, Tectone's community is now claiming that Tectone is going to sue me for defamation. You know, it's like I have been through a lot, you know, like I have been through a lot, and I do think I'm a strong person, but somebody can only fucking take so much, you know what I mean? Somebody can only fucking take so much, and I don't know, it's just very isolating to see like the people who do have like bigger voices to just like, and I get that there's so many other things going on in the world.
Uh-oh. Oh, shit. Uh-oh.
It's like they don't even have to fucking talk about me, but goddamn, fucking talk about something, fucking fence sitters. You know what I mean? Like, talk about something. Like, you know, anything. Like, pick something. Pick something. Like, there's so many things to be fighting for right now. There's so many people to be fighting for right now. And there's just like so many big voices that remain silent. And it's just frustrating.
She's mad because Hassan ditched her and isn't shouting out any of the people. God, dude. Hassan, what is the opposite of the Midas touch? He's the guy who touches things and turns to gold. Well, I guess that's technically bad too. But it's like, it's like human shields, I guess. It's kind of crazy. Hassan will like throw whole careers in front of him, watch them die on his altar, and then just moonwalk the fuck away without a care in the world. I feel like he basically did it to Ian And now these three, Denims, Kaceytron, and Frogan. Kaceytron wasn't part of the content cop, was she? Okay, no, just the other two. And Hassan is just completely hanging these people out to dry. Based, also, though, I can respect it for Hassan. Now that my eyes have been open and I'm deep enough into the community, I understand you should probably just hang all these fuckers out to dry because they'll absolutely do the same to you given the opportunity. So you know what? Player to player now. I respect it. I respect it. Except for Dan. Sorry, not Dan.
You know, it's like, would they care if it happened to Pokimane? You know what I mean? It's just like I've been so fucking isolated, and I just feel like my whole Twitch career, I've just been completely thrown to the fucking wolves to just fend for myself over and over again. And it's just like, god damn, can I not fucking catch a break? I am so fucking tired of struggling. Like, I don't mean to, like, I don't know, like people are like, stop playing victim, like this isn't a pity party for yourself. Like, I have been through so much fucking shit, you know? And then just to see like the way people are spreading all of these lies about me and the fact that I can't even control my own fucking narrative, you know? Like,
That's a big, she's a snarker Kiwi poster reader. That's a huge saying. They love to use it. I can't control my narrative. Lav used to say that a lot too.
Just to see like the way people are spreading all of these lies about me and the fact that I can't even control my own fucking narrative, you know? Like, I can't even control my own fucking narrative. Like, my voice isn't big enough to shout over all of the fucking incels shouting lies about me right now. You know, like all of these fucking people that are like, well, Kaceytron should have money. She was famous 10 years ago whenever she was a titty streamer. Like, yeah, whenever I was fucking famous 10 years ago, whenever I went viral on Twitch, that was literally the worst time in my life. Because along with that and being attacked by incels, my mother was literally in an extremely abusive relationship at the time where I should have been able to focus on my streaming career. Whenever my Twitch was blowing up, I had to focus on the fact that there was an abusive man trying to fucking kill my mother, you know? So to all of the people that are like, well, how did she not have any fucking money from whenever she was famous? I don't know. It's because of the fact that whenever I was blowing up and going viral on Twitter, I had to hide, that I would literally have to fake disconnect from my stream.
Good one, dude.
I would have to fake disconnect to my stream to go and drive over to my mother's house because she called me and just fucking left the phone on the table and I could hear a man fucking hitting her.
People keep asking how she can have 4,000 subs when not be making much money. I think Twitch changed the sub stuff a long time ago, such that you have no idea how much an actual sub gives you anymore. Like, it used to be, if you had 4,000 subs and you were like a premium partner, it would be 4,000 times $5 is 20,000 a month. But I remember, at least at the end of like Melina's, when she was streaming, when she was here, then the subs had already changed such that like people from Turkey subbing, I think you would get like less than 90 cents for a sub. Like, they changed it to a bunch of regional pricing and then they've reduced the cuts. So I think you can get like majorly fucked. Like, you can have like, because I want to say Melina was getting less than $1 a sub at the end. It was like insane how crazy the rates had been decayed or degraded or whatever.
You know? It's just like so tiresome just not having control of your own narrative and having people fucking spread lies about you and make it sound like, oh, she's a piece of shit. Yeah, she did go viral, but nothing happened with it. You know, like just like the level of just like fucking astroturfing.